All right. Your article that you're going to read is called In Defense of the Patriot Act. Here's a little background information for you. After the terrorist attacks of September 11, 2001, President Bush signed the Patriot Act. This act gave more power to federal agencies to listen in and monitor what American citizens do in public and online. The following article not only relates to the Fourth Amendment right to privacy, but also the First Amendment expression and views and civil liberties. Both of you, Emma and Justin, selected the First Amendment, and I thought this was a good mix between the both. So here's the connection that I made between the Fourth and the First Amendments for you. If you look here at the picture in the top right, it says warrantless wiretaps. So basically, you may not have the freedom to say what you want over the telephone if someone is listening in on your conversation. Online monitoring, things that you seek out on the internet. If you look over on the right side, private property searches, electronic surveillance, domestic spying, all those things relate to how you express yourself in public. And things that you need to remember is ever since 9/11 and the Patriot Act, Big Brother is watching. The government is watching you, listening in on what you say in your emails. And these things can be not only connected to the Fourth Amendment, protection against illegal searches and seizures and our right to privacy, but also how we express ourselves and the things that we say in the First Amendment. Okay, let's get started with the reading. In Defense of the Patriot Act by Heather McDonald. The recent indictment of a would-be arms merchant connected to Al-Qaeda is only the latest reminder that the threat of terrorism is as urgent as ever. Yet many among the political and opinion elites act as if America is more at risk from the Bush administration's efforts to thwart future terror attacks than from the attacks themselves. Hardly a day passes without a well-published denunciation of the government's alleged assaults on civil liberties. Cities and counties across the country are declaring themselves civil liberty safe zones, and a barrage of bills in Congress seek to repeal sections of the USA Patriot Act, the anti-terrorism law passed after 9/11, on the grounds that it violates constitutional rights. The American Civil Liberties Union recently filed a lawsuit in a Michigan federal court against the most frequent target of civil libertarian ire, the Patriot Act's business records provision. The rhetoric surrounding this provision, also known as Section 215, has been alarmist, to say the least. In an editorial applauding the ACLU's action, the Cleveland Plain Dealer, for example, called the measure of seed stock of a police state. Section 215 allows the FBI to obtain documents in third-party hands if they are relevant to a terrorism investigation. According to the ACLU, this power allows the FBI to spy on a person because they don't like the book she reads or because she wrote a letter to the editor that criticized government policy. We see some free speech issues here. After reading and listening to McDonald in paragraphs 1 and 2, does she agree with the opponents of the Patriot Act? Why or why not? What evidence does she cite? Go ahead and answer that question. Is she critical of the Patriot Act? Is she being sarcastic? Go ahead and put your answer in the first block. The charge is baseless. So going back to number 1, she obviously doesn't agree with the criticism of the Patriot Act. To begin with, it ignores the fact that the FBI can do nothing under Section 215 without the approval of a federal court. Let's say the FBI has received a tip that Al-Qaeda sympathizers have taken scuba lessons in preparation for an attack on Navy destroyers off the coast of California. Under 215, the Bureau could seek a court order for local dive school records to see if any terror suspects had recently enrolled. The key phrase here is seek a court order. It's inconceivable that the court that oversees espionage and counterterrorism investigations will approve a records request made because the FBI doesn't like the book someone reads or because she wrote a letter to the editor that criticized the government, as the ACLU claims. The ACLU also argues that Section 215 violates the Fourth Amendment right to privacy. But like it or not, once you've disclosed information to someone else, the Constitution no longer protects it. This diffuse it and lose it rule applies to library borrowing and web surfing as well. So this diffuse it, and lose it rule is interesting. Once you say something, once you write something, once you make something public, your freedom to say that or think that really doesn't apply anymore. Let's take a look here and keep reading on the next page. However, such librarians may claim otherwise, but publicly borrowing library books, patrons forfeit any constitutional protection they may have had in their reading habits. For instance, if you search something online in Yahoo, the government can't look at your computer to find out what they're searching, but they can go into Yahoo's records and find out what the user of your computer has been searching. At the bottom of the second page, McDonald's discusses the diffuse it and lose it rule. Do you agree with it? Why or why not? What I'm interested in is, do you think that once you say something or express something that it becomes public record and the government can come after you for it? Or do you think that you should have protections from the government coming after you for something that you say or something that you do? Think, for example, that library example or the Yahoo example. The government can't come into your house and look at your computer and find out what you've been looking at, but they can go into your computer through Yahoo and find out what the person who lives at Justin McKenzie's address or Emma Bowen's address has been searching for on their computers. Is that okay? I'm interested to hear what you have to say. Go ahead and put your answer down in box 2. Do you agree with that? Why or why not? Another ACLU attack on 215 uses the tactic of ignoring legal precedent. Grand juries investigating a crime have always been able to subpoena the very items covered by 215, including library records and internet logs, without seeking a warrant or indeed any judicial approval at all. Section 215 merely gives anti-terror investigators the same access to such records as criminal grand juries, with the added protection of judicial oversight. I'm not going to have you read the rest of the article, but I want you to answer question number 3. Critical thinking. Does the government have the right to target and spy on potential lawbreakers? After all, if you're not a potential lawbreaker or a terrorist, you shouldn't have anything to hide, right? Explain your answer. My point is this, and I'm not saying that I agree with this, but here's my point. If you're a law-abiding citizen, you've got nothing to hide. The government isn't going to come after you, and it shouldn't matter if you are looking at how to make a bomb or blow up a building on the internet because you're not a terrorist. So is there any harm in the government spying on us? I want to know what you're thinking.